On February 18, 2026, the Department of Homeland Security issued a new memorandum entitled Detention of Refugees Who Have Failed to Adjust to Lawful Permanent Resident Status. The memo establishes a department-wide policy requiring that refugees who have been physically present in the United States for 1 year and have not adjusted status must return or be returned to Department of Homeland Security custody for inspection and examination. This means that if a refugee does not voluntarily appear for inspection at the 1 year mark by properly filing an application to adjust status or green card application and appearing at scheduled biometrics and interview appointments, the Department of Homeland Security may arrest and detain the individual indefinitely. What this means in practical terms: the February 18th memorandum authorizes the Department of Homeland Security to arrest and detain certain refugees who have not adjusted or applied for green card status, also known as lawful permanent resident status, after 1 year. Detention under this framework does not appear to be mandatory in every case. However, the memo makes clear that detention is permitted and may last for the duration of the inspection process, which may extend beyond the 48-hour rule. In practical terms, number 1, the 1 year adjustment mark may now function as a potential enforcement checkpoint. Number 2, refugees who have not filed for green card application for adjustment, who have incomplete or rejected applications, or who fail to appear for inspection could face arrest and detention. Number 3, refugees with pending applications may still be subject to inspection and implementation details remain uncertain. Number 4, this development comes alongside broader policy shifts, expanding deportation authority and restricting meaningful appellate review. While detention is not described as automatic, the memo clearly expands the Department of Homeland Security's discretion to use custody as an enforcement mechanism tied to the 1 year statutory review. Who should be most concerned about detention exposure? Based on our interpretation of the text of the memorandum, heightened detention risk may apply to refugees who have passed the 1 year mark and have not filed for adjustment of status, refugees with incomplete or rejected filings, refugees who do not appear for required inspection or fail to respond to the Department of Homeland Security notices, refugees with unresolved admissibility concerns, individuals with criminal history or prior immigration violations. Refugees who have already applied for green cards on a timely basis and have a pending application may face lower risk, but implementation practices are not yet clear. It is highly encouraged for refugees and all non-citizens to update or keep their address current with the Department of Homeland Security's U.S. Citizenship and Immigration Services, otherwise known as USCIS. The law requires that all non-U.S. citizens file and update address changes within 10 days of moving using Form AR-11. It is also important to do this so that USCIS records are accurate to reduce the risk of missed biometrics or interview notices. Doing a change of address with the post office is not enough. USCIS correspondence is not forwarded to a new address. So, if you do not update your address with USCIS using Form AR-11, USCIS correspondence addressed to you will never reach you, which results in denied benefits and/or you may be taken into custody by Immigration and Customs Enforcement, or ICE. It is highly encouraged for refugees to seek out reputable legal service providers, such as immigration attorneys or Department of Justice accredited representatives, if they have questions about what this means for their specific situation. For more information on this topic, please visit our website, CatholicCharitiesDubuque.org, or contact our office at 319-364-7121.